Thank you for joining us at the Web-Based Municipal Law Recognition Program sponsored by the Oklahoma Association of Municipal Attorneys, or OAMA for short. My name is John Miller. I'm the City Attorney for the City of Mustang, Oklahoma, as well as a member of the board of the OAMA. One of the missions of the OAMA is to provide those practicing municipal law across the state of Oklahoma with resources to assist in providing sound legal advice to the cities and towns they represent. OAMA's web-based program that provides such information can be found at www.okmunicipal.attorneys.org. This segment provides an overview of the Oklahoma Open Records Act and addresses some specific issues that municipal attorneys should be aware of in complying with the Act. Before we begin, I want to emphasize that this segment is intended as a general overview on the topic. It is not an in-depth look at the Act, the municipal obligations under the Act, or a review of recent Open Records Act cases. One resource I would suggest, if you are interested in more in-depth information, is the Oklahoma Press Association's Open Meetings and Open Records Guidebook. This guidebook contains the full text of the Act, relevant cases, Attorney General opinions, and other helpful information. To understand the Open Records Act, we must first understand the policy behind it: public access to government records. Whether it is the Federal Freedom of Information Act, other state sunshine laws, or the Oklahoma Open Records Act, every government agency in the United States, including municipalities, operate under a general requirement that records created, received, or held by an agency are subject to public disclosure unless exempted by law. The Oklahoma Open Records Act can be found in Title 51, Section 24A. As with other sunshine laws, the Act is clear in its intent to provide public access to government records. It is the public policy of the state of Oklahoma that the people are vested with the inherent right to know and be fully informed about their government. The purpose of this act is to ensure and facilitate the public's right of access to and review of government records so they may efficiently and intelligently exercise their inherent political power. To fulfill this purpose, the Act provides generally that all records of public bodies and public officials shall be open to any person for inspection, copying, or mechanical reproduction during regular business hours. In analyzing the implications for municipalities, understand that the definition of public body is broadly defined in Section 24A3, subsection 2. It includes, but is not limited to, any office, department, board, bureau, commission, agency, trusteeship, authority, council, committee, or other entities created by a municipality or subdivisions thereof. In other words, the entire municipality, its organizational departments, citizen boards and commissions, utilities, and trusts are all subject to the requirements of the Oklahoma Open Records Act, except those specifically excluded by the Act, such as judges. Similarly, the definition of public officials, as defined in Section 24A3, subsection 4, includes any official or employee of any public body. This includes elected officials and municipal employees, as well as all appointed officials that have any duties beyond ceremonial, and includes Planning Commission members. While the Act extends a broad requirement to make records of public bodies and public officials available for inspection and copying, two major categories of exemptions exist. The first category are those records exempt from disclosure under the statutory definition of records under the Act. The Act's definition of records is quite broad, including documents, books, papers, photographs, sound recordings, videos, and other records, regardless of physical, digital form, or characteristics, if they relate to the transaction of public business, the expenditure of public funds, or the administration of public property. While certain records may fall within the larger scope of the Act's definition of record, Section 24A3 specifically excludes certain types of records as not subject to the Act. Some examples of these excluded records include non-governmental personal effects, personal financial information, credit reports, or other financial data obtained by or submitted to a public body for the purpose of evaluating creditworthiness, obtaining a license, permit, or for the purpose of becoming qualified to contract with a public body, or computer software, specifically the software itself, not the data used by the software. The second major category are those records exempt from disclosure under state statutes and federal law. These provisions are quite numerous and varied, but be aware that regardless of the provision involved, the municipality bears the burden to prove that a record can be withheld under an applicable exemption. For example, Section 24A7 provides that personnel records may be kept confidential if they relate to internal personal investigations, including examination and selection material for employment, hiring, appointment, promotion, demotion, discipline, or resignation, or the disclosure of records would constitute a clearly unwarranted invasion of personal privacy, such as employee evaluations, payroll deductions, and employment applications submitted by persons not hired by the public body. Numerous other exemptions related to employment exist under state law. They include exemptions protecting employee home addresses, telephone numbers, social security numbers, among other information. Another example are public utility records as provided in Section 24A10, subsection D. The Act provides a general requirement that utility customers' addresses, rates paid for service, charges, consumption rates, adjustments to a bill, and other information be made available for inspection by the public upon request. However, it also provides that agencies may keep confidential credit information, credit card numbers, telephone numbers, and other banking information of customers. If your municipality has customers who make payments over time, other laws may come into play in governing what records may be released pursuant to a request under the Act. The most complex example of exemptions in the Act are law enforcement records. While the general rule of the Open Records Act is that records are open and available to the public, law enforcement records are different. Instead, law enforcement agencies may keep their records confidential unless they fall within specific categories provided under Section 24A8, subsection A, such as records containing arrestee descriptions, including the name, date of birth, address, race, sex, physical description, and occupation of the arrestee. Records containing the facts concerning the arrest, including the cause of the arrest and the name of the arresting officer. Chronological incident lists, including initial offense report information showing offenses, dates, times, general locations, officer, and a brief summary. Radio or dispatch logs, records containing conviction information, including the name of any person convicted of a criminal offense. Warrant records, including orders signed by a judge of any court commanding a law enforcement officer to arrest a particular person. Crime summaries, including agency summaries of crimes reported and public calls for service by classification or nature and number. Jail registers, and audio and video recordings captured by police vehicles or body cams, subject to their own rules of exemptions, which I shall mention shortly. It is important to recognize that the exemptions applicable to law enforcement records authorize that they may be withheld, not that they shall be withheld. For example, while police accident reports are not identified as a record that must be made available, accident reports are routinely provided to the public. Furthermore, Section 24A8, subsection B provides that law enforcement agencies may generally deny access to law enforcement records except for those records specifically cited in subsection A. Those records made open by other federal, state, or local laws, those records which have previously been made available to the public through the Act, or those records where a court finds that the public interest or the interest of an individual outweighs the reasons for denial. Body camera and dash camera video and audio are subject to their own exemption rules. Dash camera video and audio are open records that must be made available for inspection to the public, but are subject to redaction. Redactions may be applied to remove death or dead bodies, except for those caused by a law enforcement officer. Great bodily injury, except for those caused by a law enforcement officer. Nudity, minors under the age of 16, acts of severe violence, except for those caused by a law enforcement officer, material revealing any personal medical information that is not already public, detentions or transportation of individuals for mental health evaluations, drug treatment, or alcohol detoxification, personal information of individuals not arrested, cited, charged, or warned, including any government-issued identification numbers, date of birth, address, and financial information, or the identity of a law enforcement officer who is subject to an internal investigation by the law enforcement agency as a result of an event depicted in the recording. This exemption is only applicable while the internal investigation is active. Body camera video and audio are considered records that must be made available if the recordings depict use of any physical force or violence by a law enforcement officer, pursuits of any kind, traffic stops, any person being arrested, cited, charged, or issued a written warning, events that directly led to any person being arrested, cited, charged, or receiving a written warning, detentions of any length for the purpose of investigation, any exercise of authority by a law enforcement officer that deprives a citizen of his or her liberty, actions by a law enforcement officer that have become the cause of an investigation or charges being filed, recordings in the public interest that may materially aid a determination of whether law enforcement officers are appropriately performing their duties as public servants, or any contextual events occurring before or after these other categories. In addition to being able to apply redactions previously discussed for dash camera records, body camera video and audio may also have redactions applied to remove victims of sex crimes or domestic violence, individuals who provide information where they request anonymity or where disclosure would pose a threat to the individual or property of the individual or others, an individual asserting informer confidentiality privilege as provided in Title 12, Section 2510, information that would materially compromise an ongoing criminal investigation or ongoing criminal prosecution. This exemption expires either 10 days after the related arraignment or initial appearance, though a district attorney can request an extension, or 120 days after the date of recording if no charges are filed, provided that the requestor must seek an appeal of the denial of records from the appropriate district court, which may extend the time frame of exemption up to a maximum of 4 years after the date of the recording. Exemptions are a complex aspect of compliance with the Act. Municipal attorneys should familiarize themselves with the more regularly relied upon exemptions, such as those for employees, investigations, and law enforcement records, while also researching specific exemptions if a request comes in for a controversial or privacy-concerned record. In addition to the general requirements of which records must be made available for inspection or are exempt from inspection under the Act, municipalities should also understand the requirements related to inspection and copying under the Act. For those records that contain information that is subject to an applicable exemption, the record should be redacted and released if the exempt portion of the record can be removed. An example would be the resume of a current employee submitted to the municipality when they applied for the job. The resume may be releasable upon request, except that it contains the employee's home address. Instead of withholding the entire document, the municipality should redact the portion of the document that is exempt, in this case, the employee's home address. Then provide the redacted version of the document to the requestor. Requesters often ask for compilations of records or for agencies to otherwise create records in response to a records request. The Act applies to records in existence at the time the records request is made. A municipality is not required to create a new record. The Act provides that municipalities may establish reasonable procedures to protect the integrity and organization of its records and to prevent excessive disruptions of its essential functions. One such procedural requirement frequently used is to require requesters to submit a written records request on a prescribed request form. Municipalities should designate an individual or individuals responsible for receiving records requests and who are authorized to make records available for inspection. These designated individuals must be available during regular business hours of the municipality. Individuals requesting to inspect records in person may utilize their own copying equipment, provided that such copying equipment does not interfere with the integrity or organization of the records, nor excessively disrupt the essential functions of the organization. For those requesting the municipality provide copies of records, cities and towns may charge the reasonable direct cost of copying, capped at 25 cents per page for 8.5 by 14 inches or smaller, and $1 per page for certified copies. Municipalities should adopt a fee schedule regarding copying fees, and posting the schedule in its offices and file it with the county clerk. The Act also gives the ability to charge a search fee for requests made for a solely commercial purpose or those that would clearly cause excessive disruption of the essential functions of a public body. This search fee cannot be charged against members of the media or media organizations. A search fee may also not be charged against anyone when release of the records is in the public interest, such as to scholars, authors, and taxpayers seeking to determine whether those entrusted with the affairs of government are honestly, faithfully, and competently performing their duties as public servants. Public officials and employees who willfully violate any provision of the Open Records Act can be charged with a misdemeanor, punishable by a fine up to $500 and/or imprisonment up to 1 year. Records requesters denied access to public records may bring a civil action for declarative and/or injunctive relief. If successful, they are entitled to reasonable attorney fees. Upon successful defense against such an action, a public body or public official may seek reasonable attorney fees only if the suit was clearly frivolous. Oklahoma municipal attorneys should be familiar with the Oklahoma Open Records Act, especially those provisions and cases dealing with exemptions of certain types of records and the production and inspection requirements under the Act. Again, my name is John Miller. I'm the city attorney for the city of Mustang, and I'm also a member of the Oklahoma Association of Municipal Attorneys Board. OAMA has established this program to provide accessible municipal law information through the OAMA website, www.okmunicipal.attorneys.org. Listed on that website is the contact information of OAMA board members and partner organizations such as Oklahoma Municipal League and the Oklahoma Municipal Assurance Group. If you are a municipal law practitioner, please take advantage of these resources and consider becoming a member of the OAMA.